The Nigerian judiciary is currently being threatened by incessant, contradictory and conflicting court orders, which has raised serious concern and suspicions, thereby questioning the authenticity of the legal justice in Nigerian courts. Opinions are divided between those who think reason plays a substantial role in the determination of judgment in the court and others who claim reasons as insignificant. Due to judicialization of the Nigeria political system and non-harmonization of courts proceedings, conflicting judgments are being given out innocently by various justices across the country. Galaxy News correspondent Lebi Joseph filed in this report.
Judgment is an act of the mind whereby the mind either denies or affirms the agreement of two objective ideas. In another sense, it is the process of affirming or denying the subject of a predicate or an attribute. Politicians run to courts with coordinate jurisdictions, apparently goaded by the tainted counsel, and abuses like this reflect the high level of decadence in our judiciary and are a clear indictment of judicial authorities. Appellate courts exist for litigants who feel they are denied justice at the lower court to seek redress.
The major cause of it is lack of unification of the judicial system, particularly harmonization of decisions of the courts. Must have resorted to that, because, to be sincere, a judge is not an island, and a judge doesn't work in vacuum. A judge reasons based on what is brought before the court.
A judgment given in Federal High Court, say Akure, there is no way the Federal High Court sitting in Owerri would know the decision given by the judges sitting at the Federal High Court Akure. So they assume jurisdiction on the same case and give an entirely different judgment.
Generally speaking, courts of coordinate jurisdiction cannot overrule each other, which is why the appellate court was established basically to challenge any judgment to the next level. It is unconstitutional for a court of coordinate jurisdiction to give directions over its equal and cannot overrule itself or its equivalent in any state. The National Judicial Council, NJC, to issue a directive that some political matters be filed centrally in Abuja and be assigned to a particular court could bring the much-needed solution.
Affidavit. You have to swear to an affidavit stating that a similar case has not been filed somewhere else. Of course, affidavit is an oath. You have to swear that this case I'm filing here now has not been filed somewhere else. This is to stop this embarrassing situation of having conflicting judgment on the same issues and the same fact.
It will be better that the NJC harmonized such a thing and unified it to the extent that any judgment delivered by a court in Nigeria will be easily accessed by other justices in the country to act as a guide, so that if a judge has read it and is going to make reasoning result of similar issue, I know such a judge would have known what to do. But in a situation whereby a judge does not have access to a judgment delivered by his learned brother, such a judge may not be able to be held responsible because he has no access to the end.
The issue of conflicting judgments is a big problem for the judiciary. In most instances, there are conflicting judgments from different divisions of the court. Conflicting judgments are not good for the interest of the court. They bring out the issue of lack of synergy between the different judicial divisions of the court, and it is high time to have a national law report of all proceedings of the Federal High Court across the country.
There is what is called obita in decisions of court. Now, if an issue is brought before a court, for instance, let's say Mr. Papa cannot be the chairman of a party. Mr. Abure is not the chairman of a party. That is an issue on its own for the court to be determined. And if a court determines and say Ababa is not recognized, that is an issue brought the court. But if in another court there is an appeal or a trial conducted in result of a case that Mr. A was nominated as a councillor under the leadership of Ababa, and as such Mr. A is not qualified to be a councillor.
If the issues raised by the party before a court of competent jurisdiction is different from the issue they raised somewhere else, you wouldn't say that conflicting judgment has been given.